Hi everyone, welcome to a simple breakdown of the UK Constitution in 4 parts. Now throughout this video you may see some asterisks, but you shouldn't worry because they only signify terms or concepts that will be later explained. The Constitution consists of 5 main components: parliamentary sovereignty, the rule of law, parliamentary government, constitutional monarchy, and the EU membership. First of all, parliamentary sovereignty is composed of 3 main points. The matter refers to the absolute and unlimited legal authority of the Parliament that has the power to make, amend, or repeal any law it wishes and on any subject. It can be reflected by the major social changes of the mid-1960s that involved legalizing abortion and homosexuality and abolishing the death penalty. Legislative supremacy refers to that no other bodies have independent lawmaking powers and guarantees the supremacy of statute law over other laws in the absence of fundamental law, meaning that the statute laws cannot be struck down by a higher body, even the Supreme Court. The Supreme Court therefore only has the right to interpret but not to overturn an act of Parliament. The equality of legislation guarantees that no Parliament could bind its successors. Any laws that have been made previously could be repealed by the next Parliament just as easily. Example, in 2003, the government repealed Section 28 of the Local Government Act, 1998, that made it illegal for the local authorities and schools to intentionally promote homosexuality, sovereignty from the public. In spite of the Parliament's rights to make or change any law it wishes, it does not always have the ability to do so, like abolishing elections. Technically, a government is allowed to do so, but with pressure groups, public opinion, world organizations, etc., and the serious political repercussions that would come along with it, it would be impossible and impractical to pass such laws, placing constraints on parliamentary sovereignty. The shifts undermine parliamentary sovereignty. At the same time, it has also been argued that Parliament may no longer be legally sovereign due to the EU membership and devolution, especially with the Westminster being reluctant to challenge decisions made by supranational and devolved bodies. The rule of law refers to the law being applicable to all conduct or behavior and covers public officials as well as private citizens. It has traditionally been seen as an alternative to a codified constitution in the UK and shows the subjection of the government to legal checks and constraints, as well as highlighting the importance of no one is above the law. Parliamentary government refers to the fusion of power, the system that is adopted in the UK. This is different from the separation of power, which is adopted in the US, because there is a fusion between the legislative and executive branches, with the Parliament and the government, as headed by the Prime Minister, being overlapping and interlocking institutions in the UK. The executive branch, which is the Prime Minister, and the legislature, which is the Parliament, is therefore one branch, while the judiciary continues to be a standalone power. This is arguably problematic as it may lead to an elective dictatorship, where the executive could use sovereign power of the Parliament for its own ends, meaning that the UK government could do or act in any way it pleases. It refers to the majority of the monarchy's power being transferred to the Parliament, Prime Minister, and government ministers. In the words of Walter Bagshot, "The House of Lords and the monarchy are dignified parts of the Constitution, wherein the latter promotes popular allegiance and serves as a symbol of political unity." He summed up the role of the monarch as having the right to be consulted, the right to warn, and the right to encourage. The House of Commons are the efficient parts of the Constitution as the ruling and choosing house. The last principle in the British Constitution is the EU membership, which expired after Brexit on January 31st, 2020. The Act 1972 gave legal force to the EU law without the need of explicit assent from the Parliament. Any questions from British courts are to be presented to the European Court of Justice for a ruling. Bear in mind that EU law takes precedence over British law until they are expired. One of many controversial topics surrounding the UK's membership in the EU is the encroachment on parliamentary sovereignty. Some argue that EU law's higher status threatens parliamentary sovereignty because, as seen from the Facto Tarme case in 1991, European Court of Justice was given the ability to quash sections of the Merchant Shipping Act 1898 that was in conflict with the Treaty of Rome, threatening a British statute law supremacy. This remains the only way that a court could remove a statute law. In addition, EU bodies like the European Commissions have supranational powers that can issue directives for the UK to follow. It means that regardless of whatever stance that an EU member state takes, these bodies are still able to impose its will, and the Westminster has no power to resist or ignore these directives issued, unless they exit the EU. Moreover, it is argued that because most decisions are made where the veto votes are not applied, the Council of Ministers that adopt qualified majority voting, the situation that nations may find themselves stuck in, as mentioned in the point above, may have a higher likelihood of occurring. Now, some argue that parliamentary sovereignty is actually embodied in the Parliament's continuing power to leave the EU, meaning that any loss of authority as a result of joining a supranational organization is actually something that the Parliament simply tolerated, as it can exit the EU anytime it wishes to, so as long as it has parliamentary support. It is also argued that the EU did not erode parliamentary sovereignty, but in fact pooled it. As countries combine their resources and work together, is more likely to achieve more than they do as independent nations. Pooled sovereignty, far from undermining a country's influence, actually gives a country more power on the international stage. A perhaps more important point is that the EU offers opt-outs in treaty and agreements negotiations, so the UK is allowed to negotiate absence from them. Policies such as the social chapter, monetary union, which is the adoption of the euros, and the Schengen agreements were some that the UK has opted out from, which also led to her nickname of being the awkward partner in the EU.